I like my presentation to be as much interactive as possible. One of the reasons is I'm, it's 10 after 12, so people are starting to think about lunch, and I don't want to keep you away from it for too long. And make it interactive, make it also more interesting, I believe. Also because as a lawyer, I tend to be extraordinarily boring. I started my career in '89, so unfortunately at this point is 26 years ago. And I've been practicing in Germany first, in England, then I moved back to Italy, then I became a French lawyer as well as an Italian lawyer. I'm admitted to practice in France and Italy, even though I'm actually practicing in Italy only, and I wouldn't dare, for the good of my client, to speak in a French court, even though theoretically I'm admitted to do that. I'm not admitted in either Germany or in the UK, even though I've been practicing in law firms there. So I've had a long career actually focusing on intellectual property, which makes me an even more extraordinarily boring lawyer. You've seen the title. I would talk about global patent enforcement strategy. And global is a terribly abused term. It's a term that a well-intending, well-meaning person should avoid. It's like left and right in politics. It's meaningless. But I have to use it because I come from a region, as Jeff said, a region where if you look at each single jurisdiction, they are probably not that important. So whenever you think about enforcing your patents, you just can say, I'm going to enforce my patent in Luxembourg. It's interesting, maybe, but Luxembourg is more or less as big as New York Cemetery, but you can only have half the fun there. So you have to think, just beyond the borders of your country if you want to have a serious enforcement strategy. And it means that you have to think in a broader way. You have to understand that global means not just applying your own criteria to other countries and say, well, in New Jersey it works this way, it must work the same in France or in Germany. It doesn't. So you have to understand that you need more knowledge than just your local knowledge. So litigation is a very interesting area because each country has its own litigation traditions and system, and each country is very different from one another. There are two main group of countries in the world, like the US, the common law countries, and civil law countries. I come from civil law countries, Italy. I've been practicing in France, which is also civil law countries, and you are in a very different legal tradition that is more similar to that of the UK, that actually you inherited and expanded. So basically, United States or common law countries are countries where the rules of precedent apply. Precedents are very important. Judges feel like they are lawmakers. They're not just interpreting or applying the law, they're making the law. In civil law countries, judges think they're basically public administration functionaries. They are looking at what the statute says and they convey the statute to the dispute and say, this is what the law says. I have no say in it. Of course, it's not true. There's a role played by the judiciary also in civil law countries, and the judge do not simply apply the enacted statute. They do something more because they have to work out what in the statute, how it applies to the specific case. But they don't feel they have the role to make the law. And of course, there are mixed countries, those who cannot decide whether they want fish or meat, and they end up like being Louisiana, Scotland, and a few others. Now, but the market for enforcement is interesting in Europe because, why is that? Because 4 of the top 10 economies in the world are located in Europe. And if you put them all together, they are bigger than China and about 3 times Japan, which is the 3rd largest. And so they have interesting countries. They are countries that are important if you want to start an enforcement project, patent enforcement project, because they are big markets. I mean, as I said, together, all of them are the 2nd largest economy. They have, of course, similarly harmonized patent laws, and we will see, but they have different litigation practices. And do you know which countries I'm talking about?
Germany.
Germany.
United Kingdom.
United Kingdom.
Italy.
Italy. and France. That's right. So here are. That's good. Geography, I can see that you managed it very well. And we do actually share some common feature. Our patent system, our litigation system does have a number of features in common. First of all these 4 countries are members of the European Patent Convention. So there is at least a common threshold that says, this is what a patent is, these are the basic characteristics of a patent, this is how you obtain a patent, and therefore these are the requirements that an invention must satisfy in order to be patentable, and this is the same in all countries. There are also European Union member states, and this means that they are subject to European Union law, and in particular, in the matter of patents, there are 2 statutes that are very important. Actually, it's a directive and a regulation. Now, I won't go into the detail of telling you what's the difference between a directive and regulation, but from our perspective, it means that there is a set of uniform laws that governs important aspects of litigation in all 4 countries. It's a directive on enforcement that says this is the minimum type of remedies that you have to grant to patent owners. And there is a regulation deciding on where, or better, which court has jurisdiction to hear of, among others, a patent dispute. So we have at least, even if we have 4 different countries and we have 4 separate litigation systems, we have a number of laws that make us less dissimilar than we used to be. And importantly enough, there's no legislation, but it's been discussed, no legislation in the foreseeable future that will restrict or impose restriction or limitations on NPE's ability to enforce their patents. And one may wonder why that's not occurring, and no one is actually thinking about the need of having a legislation of the type. But maybe because we don't have Google, or we don't have Microsoft or Apple. But I think that there's one more reason why there's no need, or the need is not felt. And we do have patent trolls, and we do have NPs in Europe as well. So in theory, big companies could fill the urge of getting rid of them. But do you have any ideas why no one's talking about a NP limitations, imposing restrictions? Well, probably one of the reasons that patent litigation in Europe is not as time-consuming, as expensive, and impose such a burden on the participants as in the United States. So the disputes are usually resolved more easily, or if they go to court, they get resolved more at a cheaper price, let's say. But let's look at each of the countries and jurisdiction, and then we can open discussion on where you're going to file your next lawsuit. United Kingdom is certainly the jurisdiction which is closer to United States, if not else because you were a former colony of the United Kingdom, of the Kingdom of Great Britain at the time. So it's a common law country. It has a very highly centralized patent litigation system. You cannot shop for a convenient venue. You don't go to Marshall in the District of Texas. You can either go to the patent court or to the high court. There are only 2 courts. And the patent court is basically a court for small patent disputes, and the high court is a court for big patent disputes. So if you are seeking damages that are not in excess of £500,000, you go to a patent court. If you want more than £500,000 in damages, you go to the high court. That's the distinction, basically. And the costs are different. It is less expensive to litigate in the patent court than it is in the high court, but you don't go to York rather than Brighton, rather than London or Glasgow to file a lawsuit. You'll be in London. There are very few judges and highly specialized. An IP judge in the Chancery Division in the High Court will only do intellectual property cases. He won't hear basically other cases. There are few judges that just do that. They were former, they're called QC or Queen's Counsel, that is highly distinguished patent lawyer who moved to the bench and they become judges. They were appointed, formally appointed by the Queen upon recommendation from the Minister of Justice. So they are really specialists. Sometimes they know more than the lawyers they are pleading a case before them. That makes the task of a lawyer very difficult. Believe me, I've been in a hearing in England where the judge was basically making fun of the lawyers, and it was tremendously embarrassing for the lawyers. I don't want anything like that happen to me ever. But So there's no jury trial. That's nothing unheard of in England. There's discovery, similar to the US, but not at all to the extent you can do it in the US. No fishing expedition. The judge is not interested in knowing what was the degrees of the son of the founder of the company when he left high school. He's not interested in that. So there's no possibility to go to seek discover documents of information that are beyond the what is strictly necessary to decide of a dispute. And it's also very quick. In general, the duration of a proceedings in England is about 1 year. It's very intense, but quick. I said 1 year, sometimes 8 months, 9 months, no more. It's expensive, but it's expensive only by European standards, not by US standards. The cost of a patent dispute in England is probably about a third of the average cost of a patent dispute in the United States. It's still expensive for us Europeans, for our continental Europeans, but certainly you find it quite cheap. Oops, I was going too fast. And the disadvantage if you're a patent owner is that the English patent system is not particularly favorable to patent owner. I mean, the London High Court was known as to be the killing grounds for patent. English judges are, I would say, they used to be more than they're moderately anti-monopoly, so they don't like monopolies like patents. And unless it's necessary, they will invalidate the patents. And you can get preliminary injunction in England, but you'll have to deposit a bond if you want to have it enforceable. And differently from the United States, the rule is that if you win, you get your attorney's fee. You don't need to prove that the other party was in bad faith or it brought a frivolous litigation. Simply you win, and since you are a prevailing party, you're entitled to recover your cost. That's the rule. And when it comes to assessing damages, there are no things such as punitive damages or treble damages. You can choose. You can try to obtain your lost profit or an account for profit. That is to calculate the profit made by the infringer in using without a permission your invention, and you can recover the profit made by the infringer. If you are a non-practicing entity, your lost profit basically is the royalties you would have obtained if the infringer had entered into the license for the patent. Germany is, I think, one of the preferred jurisdictions for enforcing patents in Europe. And why is that? Well, Germany, first of all, is a very important market. The German economy is the 4th largest in the world. And the German court, I must say, they're efficient in dealing with patent dispute. It's a decentralized court system. In theory, there are 12 courts that can hear of a patent dispute, but in reality, most of them are heard either in Düsseldorf or Mannheim or Munich. And to be honest, there's a good reason for that, because the other 9 patent courts don't get enough patent cases, and judges don't know much really about patents. So unless you are forced to have one of your cases heard, let's say in Berlin, you won't select that court for a patent case. You go there, Mannheim, Düsseldorf, or Munich. And there's a peculiarity that's unique to Germany. 5 minutes left, so I'll accelerate. A peculiarity to Germany, that is, validity and infringement are heard separately. And that's actually an advantage for the patent owner because, very simple, the infringement proceedings is actually quicker than validity proceedings. You can get a infringement decision without really examining whether the patent is valid or not. And when you have an injunction, the other party may be prompted to settle without waiting maybe an extra year for the decision on validity. There are no discoveries, so each party is simply submitting the evidence that it has been able to produce. The litigation is quick. I mean, even almost quicker than in England. And importantly, it costs probably a third. So in England, it costs a third of the US, and in Germany, it costs a third of England. So it's a ninth of the cost you would incur in the United States, sometimes even less. And the courts are, as I said, a little bit more pro-patent. And also, importantly, you can get a preliminary injunction very quickly, sometimes literally in matters of days. And then it's up to the party to get rid of it by persuading the court that made a mistake in granting the injunction. Not easy again. Like in England, you can recover your attorney's fee. And actually, differently from England, you recover your attorney's fee almost to the last penny you spent. So this is why this is one of the preferred courts.
Fabrizio, in Germany, like when we in the U.S. go to conferences or meetings now,
Yeah.
people who are professional litigators or are in the IP field, you often hear predictions that if patent law goes the way it might go here in the U.S., that Germany in particular might be sort of the next best place in the world to enforce your patents.
But I quite agree with it. Germany has an efficient litigation system. Isn't expensive, and it's quick. It's an important market. It's not like winning in Luxembourg. Who cares? If you win in Germany, any Luxembourgeois here? I remember the joke to say, that Luxembourg and the former Soviet Union were equals because they were both sovereign jurisdictions. Doesn't really work. But anyway, Germany is important. So I really think that Germany will be, or some European countries, Germany could be one, UK could be any other, France or Italy are less interesting, but still they can give you good opportunities there.
Are you already starting to see an increase either in your firm or overall?
Well, we've seen an increase in the number of patent litigation brought in Europe by American companies, but that has occurred over the past. It's not a recent trend. It's something that has started at least 10 years ago. 10 years ago, when I believe, particularly, another important jurisdiction, I've been talking about it because there are too many, is Holland, the Netherlands for cross-border injunctions, but that would have required 10 more minutes. It's too much. So, and damage. Oh, sorry, this is France. So, damages in Germany. That's maybe the weak part of a case. In Germany, damages are assessed quite conservatively. They make a mixture, say, okay, this would be the reasonable royalty, this could be the lost profit, the profit made by the infringer, and we come up with some averages, which is not necessarily, I've seen based on paralitigation, not necessarily the most generous way of calculating damages, even though the principles are all the same. I wanted to go to France, really. Well, Italy is next. So Italy is my own jurisdiction. I'm very familiar with it, and I'm very familiar with its flows, I'd say. You can look at the list. It's similar to Germany, except it doesn't work as well. So it's, we try to imitate our former allies during World War II. We couldn't make it. So it has all the advantages of a German, and a big disadvantage is that the duration of a litigation is just ridiculous. There are 20 courts. Most cases I've heard in 5, and out of its 5 courts, only 1 is capable of handling a case within 2 years. All the other courts will do it within 3, 4, or 5 years, and you just can't wait that long. In the face of this big disadvantage, there's at least one advantage, and that is how damages are assessed. And now, it doesn't work well in all circumstances, but in a certain number of industries where the big advantage for the infringer is, where the infringer is making a substantial profit out of the, unauthorized use of your patents, you can actually disgorge all the profit made by the infringer and say, I want all the money you made out of using my invention. And it's, of course, if the margin is small, it's not a big advantage. But in the pharmaceutical industry, medical device industry, diagnostics, where the margins are 60, 70%, that's a big deal. So, and it's basically, this is the only country where you apply the theory of disgorgement of profit to the fullest extent. It's questionable whether it's fair, but this is what it happens. In other countries, the law says you have to take into account the profit infringer. It doesn't say you have to take the profit infringers away. Italy is the only country where it actually says, well, you make a calculation, what's your lost profit, what the profit infringer, what the reasonable royalties, and you select where there's more money in it, and you take that.
By the way, Canada is the same way.
Is Canada the same way? Good to know. France is the best place to litigate if you're a French company. Sir.
Let me stop you there. I got a question for you.
Sure.
Jay Walker was just here, and he said, and I thought this was so good I had to write it down, unless you have a portfolio or unless you have millions of litigation capital, patents in the U.S. are almost worthless. Forget it. And we've heard other panelists say, look, if you've got one patent, forget it. don't go into litigation. There are so many ways to invalidate it. Your view, viewing
In-
European litigation, I'm a patent owner, I'm a small business, I have one European patent if I'm really lucky.
Yeah. Well, you have one at least.
Is litigation really an option for me in Europe if I have a single patent? Am I pretty much just like in the US?
I think it is. It is an option provided, and as that's only on a case-by-case basis that, upon review, your patent is likely to be confirmed valid. And I think that the prediction is easier to make here because there are not as many technicalities in the United States in assessing validity of a patent. I mean, there are a number of grounds on which a patent can be declared invalid in the United States and not in Europe, based on the same circumstances. And also you should consider if you're a small business, I mean, the cost, I mean, let's talk about that. The cost of enforcing a patent, going through a first instance proceedings in continental Europe, so it's France, Germany, and Italy, on the basis of one patent in a not particularly complex area of technology, we're talking about maybe 100,000 euros, $100,000.
To the US, you're looking at millions.
If it is a particularly sophisticated, complicated technology, biotech, something which is very sort of niche, it can be, okay, $300,000. Everyone's laughing here. Well, if you're in the UK, it will be 3 times as much, or maybe 4 times, but still, it's far less. So, if you have a small, medium-sized business, you can afford to spend $100,000 in enforcing your patents if you think you can get the money from the other party.
Okay, thank you very much.